Frederick Ole Leliman and others. And also the grounds under paragraph 105 of the Criminal Procedure Bench Book, that's from page 48 through to page 52.
Which one?
This
one, the small one.
Yes, the small one.
48.
Page 48 to 52. I realize, my lady, there are several paragraphs which may confuse. That's why I've chosen to refer to page 48 to page 52. Having said that, my lady, I wish to submit that we have opposed this bail, and the prosecution has filed affidavits detailing the grounds for opposition. The defense appears to want to eat their cake and have it. They argue that the prosecution must show that there is compelling reasons to deny accused persons bail. They argue that you need to present evidence before court. Then the prosecution presents some evidence, snippets of evidence. And they beat an about her and they say, you cannot produce evidence.
Yeah. I'm lost. You are saying they are arguing that the prosecution must show
compelling evidence, compelling reasons to deny accused person bond.
Yes.
And they say, to do this, you must place evidence. Then the prosecution does exactly that, presenting snippets of evidence. Then they make an about turn and they say, the prosecution should not have produced this. It's denying the accused person his right to fair trial. My lady, such arguments cannot and should not be entertained by this court. The prosecution has filed an affidavit, and none of the accused persons through their defense lawyers have even suggested to cross-examine the opponent of the affidavits. All they are asking the court is to dismiss the assertions offhand without any cogent reason. They also argue that the accused has been tried by the public and convicted. I do not take that to be an argument for release of accused person on bail. That is political rather than legal, because if the accused has been convicted by public, why is he here? What are we doing here?
That's a good question to ask.
That's the question we pose. Even these accused persons have been convicted, we will not be here. So that is an argument which cannot be relied to grant the accused person bail. Then, my lady, the accused persons argue that the accused are married with families. And children. I've never seen anywhere where that is a consideration for grant of bail. And I urge the court to dismiss that argument. Then the accused persons and their defense lawyers argue that the right to bail is a fundamental right, which we appreciate, but we submit, my lady, that there is no right superior to other rights, and rights of accused persons must be balanced with rights of other persons, other members of public. Then my learned senior former learned judge, Mr. Umbicha, argues that this court is meant to address the misrules of on account of the judiciary previous that the misrule we experience today is on account of the judiciary. Under the old constitution. This is not a political case. This is a murder case. And we submit that the previous misrules, which of course have not been stated before you, have nothing to do with this case. And the factors that the court should consider, which are outlined, my lady, as I've said, in the various authorities, are not cumulative, but alternative. The prosecution need not show that all facts or factors have been established. And the fact that accused persons are not mentioned anywhere in some of the statements so far provided and underline the word here directly, does not remove the fact that a case can be proved with circumstantial evidence. An attempt was also made to show that murder no longer carries death penalty following the decision in the Moruate case. That cannot be far from a lie, because the Constitution does not prohibit death penalty, and the court, in appropriate circumstances, may impose death penalty. And this is a case which we'll be submitting is appropriate for imposition of death penalty if the accused persons are found guilty. And then there was one, I think, misapprehension that the committee of bundles supplied should not sway the court's view. We have not submitted committee of bundles to court, as this is not a trial, and the court will determine this issue of bail not based on the evidence, the totality of the evidence we are going to rely on, but on the cumulative factors we have established through our affidavit. Then Mr. Amolo, my learned colleague, argued that the court is bound to give bail and that it's the state to indicate opposition to bail. We have done this. We did this from the onset, and we have filed our affidavit at the earliest opportune time. And invited the court to apply Section 72 of the old repealed Constitution. The repealed Constitution, my lady, has no force of law anywhere, and it was even his own emphasis that bail may be denied upon reasonable suspicion of one having committed an offense. And we have submit here, we have established here, there is reasonable suspicion that all the accused persons committed the offense with which they are charged. As for accused number 3, argument that he is not an employee of the first accused, I do not know where this comes from, because at paragraph 23 of the affidavit filed by the prosecution, we have clearly stated that the accused is an employee in the county government of Migori. Unless, of course, the argument is the first accused is the county government of Migori. The facts have not changed in respect of the first accused when we were here, other than the fact that, indeed, all the accused persons are now faced with 2 counts of murder. And that is a factor also to consider when determining this application for bail. I'll now invite my colleague to pick up from there, and we have arguing in respect of the application by Michael Amo and any other factors.
3 minutes.
3 minutes?
Yes.
I'll try to condense my arguments.
For the whole thing, it was 2020. I'm at 2020.
Allow me to begin with the question whether the grant or denial of bail is an issue of discretion by the court. And in my humble submission, Article 49 makes it clear that where compelling reasons do exist, then the court has discretion to consider whether to grant or not to grant bail. That is the position in our country. And my lady, in support of that argument, allow me to cite a decision from the Supreme Court of India. I have shared a copy with my learned friends. The case of Babu Sin, and in that decision, my lady, the court considered, among other things, when a court is to exercise discretion in favor of accused persons for bail and when not to grant bail. In particular, I wish to draw your attention to page 2, the holding as stated at page 2 of that decision. And that covers the renewal of bail applications in stages, such as been done by the first accused. My lady, in exercising discretion, the court is expected not to innovate at pleasure, but to act on well-consecrated principles that courts have laid down on the matter of bail. One of those principles is to be found in the case of Danson Mugunya that my learned friends have relied on. It is in the bundle filed by Michael Oyamo. It's the very last decision in that bundle. Sorry, second last decision. Lady, I would invite you to look at page 369 in black print, 94 at the top. That is unwritten. And the judge, yes, the judge recognizes that affidavit evidence can be adduced. That is the point we're making. In respect of Michael Oyamo, we have given you evidence. The only point you consider, my lady, then is what is the burden of proof? In my humble submission, the burden is on a balance of probability. Nothing has been presented to displace the material we have placed before you, and therefore his application for bail must fail. That's it.
My lady, on behalf of the victim, I wish to only submit on 2 points, and Professor Wadakoya will deal with the rest. Your Ladyship, we have produced the replying affidavits that have been filed on behalf of the first and the second accused persons in response to our affidavit filed by the deceased mother, and the submissions of my learned senior colleagues. Your Ladyship, they have submitted that actually our affidavit offends section 9(2) of the Victim Protection Act. Your Ladyship, it is a humble submission that in fact section 4(2)(b) of the Victims Protection Act stipulates that at every juncture where a decision is to be rendered by the court, such as the bail application before you, the victim ought to be given an opportunity to be heard or to respond. And therefore it is our humble submission that filing of an affidavit is the opportunity to respond. Your Ladyship, without belaboring the point, this court has already pronounced itself severally on the issue. And it must be distinguished that the rights of the victim to respond or to be heard at the stage of bail application is different from a victim impact statement as contained in Section 2.1 of the Victims Protection Act, as well as Section 12.1 of the Victims Protection Act.
Sorry, I think you lost me a bit more. You said it should be distinguished from?
Yes, that the affidavit we have filed in response to the bail application ought to be distinguished from the victim impact statement as described in Section 2.1 of the Victim Protection Act, as read together with Section 12.1 of the Victims Protection Act, and which restrict the victim impact statement to the sentencing stage. Your Ladyship, it has also been submitted that the matters deponed to in the affidavit by the deceased mother touch on matters to do with the investigation and or conversations between herself and the investigating officers. Your Ladyship, it is our humble submission that the victim has a right to information under Section 19.1 of the Victims Protection Act, as read together with Section 9.1e of the Victims Protection Act, which both empower the victim to be supplied with evidence as well as information by investigating officers in the matter.
My Lordship, I would like to, if you permit me, say that I'm the last.
I don't know whether I get your name correct. Can you spell it, please?
It's W-A-J-A-C-K-O-Y-A-H.
Yes.
My Lordship, first and foremost, I'm very thankful because I'm the last born today. I think there's nobody else who is going to speak after me other than the other tier that is coming in. We completely adopt what has been said by the state, plus my colleague here, and I will not waste more than 2 minutes, Your Honor, Your Ladyship. That the state has satisfied the tenets of compelling reasons, which I am not in this, at the particular moment, going to adhere to. But the victim's affidavit's reliance on the IOs, investigation officers' point of view is covered in the IO's affidavit. And therefore there's nothing new or anything sinister to be cried upon by my learned counsel on the other side of the aisle. My lady, may I also draw your attention to the maxim of equity. Equity requires clean hands all the time. But we have unclean hands here because the prosecution, the defense has come in to denounce their own game plan by saying that the other side of the aisle was relying on evidence Yet, they have looked into a committee of bundles, which means they have looked into evidence, and they have come out now to say that others should not look into evidence, which means that they're not being sincere with this honorable court, as was previously alluded to by counsel from the state, where they said that we are relying on evidence. Yet they have relied on evidence. Well, how? By reading the bundles. Equity requires clean hands, but they should not come in with dirty hands. I rest my case, Your Honor.
That's the PCZ,
I'll respond.
5 minutes,
5 minutes.
and try to respond, not to bring argument.
Yes, but I'd also like to indicate that in criminal matters there is nothing like equity.
What is that?
They must prove that beyond reasonable doubt. Let's start from there. My lady, let me start by just giving an example that is descriptive. The statute that we are given that shows justice. On one hand, the person dispensing justice has a sword, and on the other hand has a scale, but blindfolded. That was put there not because of just an assumption.
Am I supposed to write that?
Yes, my lady, because if you cannot write it down, at least then listen to what I'll say about it. My lady, there is no chance at that particular moment when you're dispensing justice for you to put that sword down and remove the blindfold, because that means you'll be peeping into evidence. And that's what they're not telling you. That blindfold is there for a reason. So when they tell you look at evidence, then we are at a position that is disadvantaged. And every time they will come to court, they will tell you that they have strong evidence. And that has been what is put down in many of the authorities. They'll tell you that they have strong evidence. How do you have an opportunity to look into that? Because the moment you look into that, again I'll repeat, we are at a disadvantage. My lady, today the prosecution have come up with their response. And I'd like to answer my learned colleagues led by Mr. Ondari on one very simple thing. Interference of witnesses. What have they shown to you today in this court? What have they shown to you? They have shown you nothing. And that is why we said we needed evidence on that, not anything else, that somebody has interfered with a witness, and which witness. For the accused person to abscond, in all those authorities, it has been said evidence must be placed before court. That is the evidence we're talking about. So have they shown you that the accused person, the first accused person, has attempted in any way to abscond or prepared to do so? That is the evidence that we want them to produce today. And I remember in their first affidavit, they spoke of the influence of the governor. They spoke of the influence of the first accused person in that county. So we left it hanging, hoping that today, they would show us how that influence is going to affect this case or the witnesses in this case. Until that point today, they have nothing. So then let us ask ourselves, what is compelling reason? Because that is the question they have avoided to tell you today.
Those compelling reasons is the material they need to place before court, and they have not done that today. In all the affidavits that they have used to reply, everything there has been on guess form. Let me put it that way. They are guessing. They want you to speculate, to join them and hold hands and speculate with them because they have nothing.
My hands are still at
That is why they want to take the sword so that you can. They have nothing, and that is why they want to join on that aspect. My lady, when an accused person comes before you and tells you he is married and he has got children, what's wrong with that? He has come to show you that he has got ties in this country. He has got reason as to why he cannot abscond. He's got reason as to why he will attend court. And that is where Article 50 of presumption of innocence has to come in, because life must go on. They cannot be in custody because they have children. The presumption makes it possible for them to go on with their life. That is why it is there. It cannot stop. That is why they needed to show you that he has no ties in this country. But they to do that. And what do they expect? They are telling you that the accused person, and that is the first affidavit, has harassed witnesses. But the only affidavit that tries to bring up that issue is the article of the victim, paragraph 29 and paragraph 30, which has been... It shows in article 29 that one of the victims was attacked and has reported in a police station. My lady, if you look at that paragraph, clearly shows you the person attacked was attacked somewhere in Nairobi. The affidavit refers, the OB refers to somewhere in Nairobi. Attacked by 5 persons, and he was robbed. It's a robbery case, if at all it exists. It is nothing else to do with this case. In that same affidavit, they do not say whether those people mentioned the first accused person. Mr. Obado was there, or that is the one who sent those people. He does not. It does not say where exactly he was attacked. It does not give the person's name, the one who was attacked. So how do they expect you to imagine this situation? So what they needed to do was to bring evidence that the first accused person was actually involved in that attack. In the absence of that, you need to ignore what they are saying. In any case, my lady, no new affidavit has been filed in response to our application. And that can only be one reason. They have no material to respond to that application. They have nothing. Because if they had anything, including the statements that they were harping so much about, today they would have attached them. But in the absence of that, there is nothing. So they cannot come here and stand and start arguing with us and indicate to the court that...
Are you looking at the watch? It's up.
Huh? My lady, I can't give another 5 minutes.
Because you started by giving us a story.
No, the story was pretty good, my lady. But my lady, let me just wind up by saying that in the absence of any evidence that they have given you today, in the absence of anything, and they give you an authority, these authorities cannot dislodge the words of the Constitution, whether from India or any other institution. What we are going for is, or by, is the Constitution as it is. So let me just give you another example, my lady, and this is the last one. When we come before you, we are lambs. and you are the shepherd, and you have that staff, and that staff is what you use to guard us jealously. And sometimes use that staff to fight even the wolves. And I'm not going to say the wolves are here today. My lady, let us not even look at the first accused person with the position that he holds today, because that one they have not responded to. But let us start by saying that this justice that you have to dispense under Article 27, Sub-Article 1, it provides for equal protection and benefit of the law, which is what not they have told you today. They have not said anything about that today. They ignore Article 159. Yes, Article 152, 159, Sub-Article 2. Justice should not look into the status of the person, because if we look at the status of the person today and see because he's a governor or anything else, we will have discriminated against him. We will have discriminated against him. My lady, it is such a struggle with this prosecution. Ignore them.
Even though the court is blindfolded, you have to look in everywhere, including yours.
My lady, look at us.
You're arguing about keeping balances, isn't it?
Yes, my lady. And that's why we would want you to start by
And
looking
that's
at
why the
Article 20.
balance has two sides. So if one falls more than the other, that's not fair.
You know what they're doing? They're standing behind you and they want to remove the ribbon. This is what you use that sword for.
I hope you're not making me a shepherd or a butcher. Start with your name.
My name is Abisai, my lady.
I think I used to know you in the past.
I'm glad that you still remember me. My lady, the prosecution led by my senior Mr. Ndari and Mr. Muteti have not urged any compelling reasons, even as they stood before you. They did not. My lady, all they did was to rely on the affidavit that was filed by their witness. And I want to take you, my lady, to this affidavit of Clement Mwangi. This is an affidavit that is full of falsehoods, some of them very blatant. And I have in mind paragraph number 23. And in this paragraph, they are saying that...
43 or 23?
Number 23, paragraph 23 of this affidavit. They are saying that that Michael Yamo Juma is the governor, Migori County. I have not even attempted even to correct that. And they want you to believe that indeed this statement of theirs, which is on oath, is what should be relied upon. If they lie on such a material fact, such a basic fact like that one, what else do we know they have lied upon in this affidavit? Much of the material that is presented there is hearsay. All that they have decided to do is to build the prosecution case in this bail application. And your leadership, those are not compelling reasons.
This really responds to this, our submission. So they're trying to argue the case by buying time through response.
Yes, it is on.
Let him continue a little bit, then I'll know which
Most of life, your leadership. The compelling reasons, my lady, are different from the evidence that should be presented on trial. They cannot present evidence here and then call this evidence compelling reasons. My lady, Mr. Muteti has quoted the case of Republic versus Mugunya and another, but he has selectively tried to apply the same, and more particularly in on page 370, paragraph E. My lady, that decision is very, very clear, and they would wish that you close your eyes to the same, but this is what it says.
Did you say page 370?
Yes, page 370,
Yes.
paragraph E, where the judge stated that I am of the view that in time, trial courts in Kenya may need to set out basic criteria for our own situation and circumstances. However, I am of the view that most of the criteria set out are reasonable and ought to apply in our cases, with a caveat that the most important critical criteria is whether the accused will turn up on or be available on trial. And more important, it says, I think that the criteria number 2, which is the strength of the evidence which supports the charge, I think the criteria 2 above ought not to apply in Kenya, except where perhaps the application for bail is being made or renewed after the court has placed the accused on his defense. They don't want to tell you that.
Your time is up.
So, my lady, I know in due time you will go and look at these affidavits very critically. And we pray that in absence of any compelling reason, they have not presented any, kindly grant accused number 2 bail. That is our prayer.
Please, for the card, please.
My lady, I am present. My lady, I will be very brief. My lady, in response, first we reiterate the submissions earlier made on behalf of the third accused person. My lady, we join hands with the prosecution in appreciating that bail is right. That is the rule. The second limb of that particular article brings an exception, which is the provision of compelling reasons. And humbly, Your Ladyship, we submit the prosecution has failed. At your own time, Your Ladyship, we urge you to look at the affidavit on which the prosecution is laying its claim. That is the affidavit by the IO. My lady, cleverly, they have merely rehashed the ground set in the bail and bond policy guidelines and section 123 of the CPC. Almost word for word. But where is the disjoint, Your Ladyship? They have merely thrown the allegations based on that section to the face of the court. For my lady, not a single attempt to prove any of those grounds. Zero. In fact, Your Ladyship, in their attempt, they clandestinely.
No, but my lady don't think.
My lady, he does not know what I want to say next.
Whatever you are going to follow, what is going to follow?
I will
Clandestine
rephrase, Your
is you know the.
I will rephrase, Your Ladyship. They cleverly.
In fact, everybody should quote the bail and bond.
Yes.
It's a good thing.
Cleverly, Your Ladyship. He is even losing me, what I was saying. But I'm saying, but I'm saying, Your Ladyship.
You are using the word clandestine, which of
Yes,
course is
they
different.
cleverly bring out evidence meant in proof of the charge, not of compelling reasons for bail. So preliminarily, Your Ladyship, they are trying to get to the back of the head of the court what evidence they have in support of the charge. What my senior Mr. Mbeta saying, removing the ribbon. Your Ladyship, you've been referred to authorities by the prosecution, specifically the authority of Olele Liman, Republic versus Olele Liman. In response, I will be brief, Your Ladyship. One, each case should be decided on its own facts. And two, and most importantly, Your Ladyship, we urge you to look at our bundle of authorities, specifically authority number 3, number 5, number 10, and number 12. Your Ladyship, they give you an answer.
Authority number?
3, 5, 10, and 12. They give you a response to every issue raised by the prosecution. My lady, you have, they have pointed to proportionality of rights under the Constitution.
You wind up.
I am winding up. The proportionality of rights, my lady, I'll refer you to Article 24(1)(d). My lady, if you read that together with Article 24(2)(c), the answer is there. In that they should not use that proportionality to derogate even the rights accorded to the accused person by the Constitution. Look at their paragraph 23 of the affidavit, my lady, you will find very interesting facts. They call my client a PA to the governor, working at the behest of the governor, which is a misleading fact. Finally, in winding up, my lady, they have correctly put out that the third accused has not been mentioned anywhere, but saying that circumstantially somewhere along he may be tied. I will leave that to the court. And humbly, your ladyship, we will beseech this honorable court to be pleased to consider the third accused person's application. Find that there are zero compelling reasons provided by the prosecution and humbly admit the third accused person. That is all, Your Ladyship.
I want to give you a ruling on the 24th at 9 o'clock, 24th of this month. Anybody with a problem with that day?
Yes,
24th of October?
Yes, my lady. We would urge the court on behalf of the second accused, if it is possible to get the ruling earlier, considering that the accused has been in custody from 4th of September.
The 24th is not good, I push forward.
We are praying to come earlier, my lady.
No. In fact, this is too early, I should push it a little. So 24th, 9 o'clock.
Lady, if that is the earliest available.
Yeah, it is the earliest.
We shall be obliged.
Excuse me.
There will be a ruling on the 24th of October at 9 o'clock.
Yeah, obliged.
What is that,
Niko tayari. Na bila shaka mtazamaji, kama unavyotazama hapo ni picha yake Obado pale kizimbani pamoja na wale washukiwa wenzake wawili ambaye ni Michael Juma Oyamo na Kaspalo Obero, baada ya mawasilisho haya kutoka kwa pande zote mbili, upande wa mashtaka pamoja na upande wa walalamishi ambao wamewasilishwa na kuwakilishwa na mawakili mbali wakiongozwa naye Clifford Mbeta pamoja na mawakili wengine zaidi ya 4 ambao wametoa wasilisho wao mahali hapa, akiwemo Profesa George Wajakoya na wengineo ambao kwa sasa hivi tunavyoweza kuripoti ni kwamba tayari Jaji Jesse Lesit amesema baada ya kusikiza pande zote mbili, amesema kwamba uamuzi utatolewa tarehe 24 mwezi huu wa Oktoba kuhusiana na iwapo ataweza kupatiwa dhamana Okoth Obado pamoja na wenzake au la. Kumbuka upande wa mashtaka wakiongozwa na wakili wao Jacob Ondari Tom Imbali pamoja na Alexander Muteti walikuwa wameshikilia kwamba kwa mujibu wa ile hati kiapo ambayo ilikuwa imetiwa saini na bwana Clement Mwangi ambaye ni afisa wa ngazi ya juu ya upelelezi wa jinai serikalini kwamba hafai kuachiliwa huyu Okoth Obado pamoja na wenzake wawili ambao wanashtakiwa na kushtumiwa na mauaji yake Sharon Otieno ambayo yalitokea mwezi jana tarehe 4 baada ya kutekwa nyara na kupatikana katika msitu akiwa ametupwa pamoja na mwanawe wa umri wa miezi 7 tumboni kufariki, kwamba iwapo ataachiliwa basi huenda ikaweza kuleta hitilafu katika uchunguzi na upelelezi wa kesi nzima. Kumbuka pia kuna kiapo chingine ambacho kilikuwa kimetiwa saini kwamba kuna mmoja wa wanafamilia ambaye alitekwa nyara, na hivyo ikasemekana kwamba kwa mujibu wa mawakili wa familia kwamba ni moja wapo ya sababu ambazo zimewafanya kwamba waseme Okoth Obado na washukiwa wale wenzake wawili Michael Juma Oyamo pamoja na Kaspale Obero ambaye ni karani katika bunge lile la Migori wasiweze kuachiliwa. Kumbuka wakili wa mwisho ambaye ametoa hoja zake bwana Abisai amesema kwamba ni katika hali ya kuweza kupotosha mahakama kwa kumuita mlalamishi wake ama kwa kumuita mshtakiwa wake ambaye ni mteja wake bwana Pascal kwamba alikuwa akifanya kazi pale kama msaidizi pamoja na Michael Oyamo, kwamba yule hakuwa msaidizi wa Okoth Obado kwa njia yoyote. Na mtazamaji, kama unavyoona kesi hii ama koti hili linavyofumuka, tunataraji tena kurudi hapa mnamo 24 Oktoba ili kuweza kupata uamuzi kwa mujibu wa jaji Jesse Lesit. Ni kesi ambayo imechukua zaidi ya saa 1:30 siku ya leo kuweza kusikizwa, ikiwa ni mara ya pili kuweza kufika mahakamani kwa ajili ya kusikiliza na kuwasilisha ombi hili la kupewa dhamana kwake Okoth Obado. Lakini kumbuke Ijumaa pia kesi hii ilisikizwa bila Okoth Obado kwa mahakamani. Kwa hivyo tutasema ni mara nyingine ya tatu mbali na zile mara mbili zingine za kufika mahakamani kwa ajili ya kuitikia kesi hii ambayo inamkabili Okoth Obado, gavana wa Migori, ambaye kaunti atokayo ni kaunti ambayo kwa sasa hivi imekuwa katika kibaridi cha muda mrefu sana, inaelekea mwezi mmoja wa kuwa bila gavana wao, isipokuwa siku 4 zilizopita waliweza kupata seneta wao mpya ambaye ataweza kushikilia labda hatamu za kuweza kuongoza pale kwa masuala ya kisheria, Ochilo Ayako ambaye alichaguliwa, lakini inaonekana watasubiri zaidi. Na mwana Okoth Obado pale gavana wa Migori akiwa anaelekezwa nje na wasimamizi wa mahakama hii ya Milimani, waendesha mashtaka pamoja na maafisa wa polisi, akiwa bado iko chini ya ulinzi. Kumbuka kesi hii ambayo kwa sasa hivi imefika siku yake 40 imeweza kushuhudia mengi tu, yakiwemo Okoth Obado kuweza kupelekwa hospitalini, hospitali kuu ya Kenyatta ya kitaifa kwa sababu ya maradhi ambayo yalikuwa yanahusishwa na tumbo, na vile ikasemekana pia kwamba awali kabla kupelekwa katika gereza lile la mahakama ya viwanda alikuwa akipendelewa kwa kiwango fulani, lakini hayo yote akaweza kupuziliwa mbali. Na mtazamaji, ndo hivyo tutakuwa tunaendelea kuifuatilia kesi kwa karibu sana, ambayo imeweza kutoa macho ya wengi kabisa kuangalia itaisha namna gani na kuweza kutoa mwelekeo wa kesi zingine kama hizi. Wa Mombo wakasema president ambayo inatarajiwa kuweza kutolewa, tunatarajia tarehe 24 uamuzi huu uweze kutolewa na jaji Jesse Lesit. Kutoka kwangu naitwa Loft Matambo kutoka mahakama ya Milimani. Endelea kutazama taarifa za KTN News kwa mengi zaidi kuhusiana na kesi hizi na